Okay, so we will start the session. So today is the last day of our Bharatiya Nyaya Sanhita, and I hope it will be little fruitful for all of you. At least you all get a understanding of what is Bharatiya Nyaya Sanhita. I would suggest you to have a bare act. Just go through the bare act, and probably that will be the best thing, and you will be benefited more. Is the screen clear, right? Okay. Just a second. Yes. Now, before we move to the further chapters of BNS, I would just like to revise little law. When we say law, what is law? How would we define law? Law is, basically human idea, attitude, or a behavior of a human towards it and political society. To regulate all these, emotions, ideas, we need certain, we need law. Law is also influenced by judicial interpretation and application of judicial mind. As in our previous session, we have seen how the judicial interpretations and judicial decisions have influenced most of the new concepts that have been added to BNS. So this is what is all about law, and when we are discussing about criminal law, then we need to understand criminal law is about the attitude, about the behavior of a person towards each other, towards the society, towards the environment. Okay, so moving to chapter 13, contempt of the lawful authority of public servants. This was there in IPC as well, and you can see on the screen that it's chapter 10 of IPC, which is chapter 13 of BNS, section 206 to section 226. I have just taken the important sections where the changes are, done. I will be giving a references to them. But there has been minor changes throughout the BNS. See, the punishment, be it imprisonment, be it fine, it has been enhanced. Now, if you say, 50 rupees, the enhancement is actually five-fold, or, at times it's tenfold also. There is a punishment, there is a fine for 2 lakh also. So if you see the amount has increased so much, then a question might come to your mind that, why it's increased so much when it was 100, when it was 50 earlier. But then just imagine rupees 50 or rupees 100, the value of this in 1860 when the criminal laws were enacted. That time the value of that amount is equivalent to the amount that has been increased in the present BNS. Now, let's discuss chapter 13, which is about contempt of lawful authority of public servants. Now, it says that whoever, will restrict the public authority, will restrict the public servants from performing their work, they will be penalized. They will be punished. So section 206 to 208, there is an enhancement in the, amount of the fine. For instance, earlier it was 500 for absconding in an old service of summon to other proceedings. It was 500, which has been increased to 5,000, where the fine was 1,000, it has increased to 10,000. This is how it has, majorly there is enhancement in the fine amount. Now to 209. Section 209, which is about non-appearance in response to the proclamation under Section 84 of Bharatiya Nagarik Suraksha Sanhita 2023, which has replaced our CRPC. Now it says that in case whoever fails to appear on a specified date, on a specified time, then such person will be punished for an imprisonment for an extent of 3 years or fine, or he can be punished with community service as well. Now, I have told in the previous two sessions about the community service, and I have told you that community service definition is not given in BNSS. BNS. We can take reference from section 23 of BNSS, where in illustration, the explanation, the definition, you can understand. But then again, it's not given at to what extent will be community service. So it will be totally the discretion of the court that what will be the community service, what is the act, and under what circumstances, what are the conditions where the community service can be given as a punishment. Two thousand ten to 210 to 215. Again, there is an increase in the amount. 216, there is no change. It has been taken as it is from IPC, section 224 to 25. Kindly mute yourself. I'll take all the queries. I'll take all the doubts at the end of the session. Kindly mute yourself. 217, there is increase in fine is increased, and there is enhancement in the imprisonment also from 6 months to 1 year. 218 to 223, the punishment and fine both have been enhanced. Now 226, it's a new provision, it's new addition to the BNS. Now it means that any person, any person who restrains the public servant from the exercise of his duty by stating that he will commit suicide, then such person will be imprisoned for the term which may extend to 1 year, or fine, or both, or with community service. Now, suppose if a person goes to a public servant and, the person says that if you release this order, then I will commit suicide. So this is unlawful. This is restraining the public servant from performing his duty. So this attempt to commit suicide to compel or restrain exercise of lawful power. So whoever attempts to commit suicide with the intent to compel or restrain any public servant from discharging his official duty, he will be punished with simple imprisonment for a term which may extend to 1 year, or with fine, or with both, or with the community service. See, community service is, very rehabilitative theory that they have added in this BNS. And it's going to probably, we'll need to see in the future how this is applied and what is the consequences and how is it taken by the public also. Chapter 14 of false evidence and offenses against public justice, which this chapter 14 was chapter 11 in IPC. Sections 191 to section 229, it dealt with now, before I move to the next slide, What is false evidence? So whoever, false evidence you have studied, any person who is making a false statement under the oath, who is giving a false declaration as to evidence, and if there is any fabrication of false evidence, and if such person is legally bound by the oath to state the truth, and if he intentionally does not, if he intentionally is fabricating the evidences for the purpose of being, used in any stage of the judicial proceedings, then he will be charged as for the false evidence he is giving. Just a second. Just a second. Actually, let me just admit few are waiting to get the. Okay. So the key elements of the false evidences is what? False statement under the oath, false declaration as evidence, and fabrication of false evidence. Yes. Section 229, punishment for false evidence. Earlier, there was no specified amount mentioned. Now, again, even in 229, if I'll just read it to you, 229. See, it says, whoever intentionally gives false evidence in any stage of a judicial proceedings or fabricates false evidence for the purpose of being used in any stage of the judicial proceedings. Okay. And if you see the clause 2, it says, whoever intentionally gives or fabricates false evidence in any case. So earlier it was clubbed together. But for the purpose of simplifying it, for the purpose of clarity and for easy understanding, in BNS, it's given in two subsections. So judicial proceedings and other cases, it is in now in a separate subsections. Hence, the fine amount, which was not, clearly, or earlier there was no specification as such mentioned. Now it is 10,000 for judicial proceedings and 5,000 in other cases as a punishment for false evidence. Similarly, in 230 section, giving or fabricating false evidence with the intention to procure conviction of capital offense. Now, earlier, this fine amount was not specified. It was just said, imprisonment and fine. But now in BNS, they have specified the fine amount, which is 50,000. So, this is again to maintain the clarity that fine means this fine. This is a kind of, summary trial. What happens in the summary trial? Easy trial, right? So it's again, if the mention is there, it's making it more clear. It's more simplified. There is no change in 231. And there are changes pertaining to the enhancement in the price in this fine amount from where the fine was 1,000, it has increased to 5,000. 241, destruction of document or electronic record to prevent its production as an evidence. See, since the term electronic has been added And we have seen in the definition also of the document. So the document, not only the physical document, but yes, an electronic medium, records are also document for the purpose of BNS. So this evidence, this electronic record, be it any electronic file, the hardware, the software, they all come within this. And this definition, yes, you can take reference of IT Act as well. 243, which was section 206 of the IPC. Fraudulent removal or concealment of property to prevent its seizure as fortified or in execution. Here also in 206 IPC, there was no specific mention about the fine amount. So the change is the fine amount is specifically mentioned here. False charge of offense made with intent to injure, enhancement in the imprisonment, and there is fine up to 2 lakhs. Section 268. It said personation of assessor and juror. So this term, since it was from the colonial era, so this term juror is deleted. If you have understood, now in present time, we do not have the jury system. This jury person, this jury man, they were the laymen, and their opinion would matter for the judgment in the court. But now we have a judicial system where the judge is of the opinion and the law is there to help him to understand and to give the judgment. Hence, this juror, the term juror, it has been deleted. It has been deleted from BNS. Chapter 15 of offenses affecting the public health, safety, convenience, decency, and morale. Now, when we talk about offenses affecting the public health, safety, convenience, decency, and morale, two concepts that you have studied and taught also, that is nuisance, public nuisance and private nuisance. You have studied this, and this is what is given in 270 of BNS about the public nuisance. 273, disobedience to quarantine rule. Now, this was there in the IPC also, but there is the addition of any mode of transport. Now, this any mode of transport is actually a wider concept. Now, it includes any kind of vessel, any kind of mode of transport. Disobedience to quarantine is for the purpose of, there is no spreading of any infectious disease. During the COVID time, we have seen the situation, how it was. So it's basically about that, this has given this effect, and hence we have this addition, any mode of transport, so that there is no spread of any infectious disease from any place to another place. Now, any person who disobeys this, he will be punished. He will be punished with the extent of 2 years, or with fine, or with both. So earlier it was just a vessel, a limited scope, but when the term any mode of transport is added, the scope has been widened. Section 274 to section 278, it's totally about the enhancement in the fine amount. 279 is increase. It's increase in the imprisonment term. Now, exhibition of false light, mark or boy, where the fine is not less than rupees 10,000. Now, where a person puts another person in wrong impression, there is misrepresentation. This is what is false light. So earlier, for this, there was no fine. There was no fine mentioned for this. So in BNS, the fine of rupees 10,000 is given if anybody exhibits of the false light, mark or boy. Section 284 to section 289, there is increase in fine. 290, negligent conduct with respect to pulling down, repairing or constructing building. Now this construction of building, this has been added now. Because we have seen the incidents, where the material that is used for the construction, it's not as per the requirement or the approval that has been given to these construction companies. And we see the consequences where there is harm to the human body. Now, for this purpose, again, it's again, I'll say it's the outcome of the judicial decisions, judicial pronouncements, that construction of building is added in our BNS. So if we read, I'll just read this out to you, section 290. Whoever in pulling down, repairing or constructing any building, knowingly or negligently omits to take such measures with the building as is sufficient to guard against any probable danger to human life from the fall of building or of any part thereof, shall be punished with imprisonment of either description for a term which can extend to 6 months or a fine which can extend to 5,000 rupees. So you can understand this. Probable danger to human life. Hence, this has come within the ambit of the provisions of the criminal law. Section 291 to section 294, there is increase in the fine. Section 295. Earlier in this section, actually the word was used that anyone under the age of 20, this was in the IPC. Now this has been deleted for the purpose of gender neutrality. It has been made any child. Okay. Section 296 to section 297, fine amount is added. Earlier, there were no fine in it. Chapter 16 of offenses relating to religion. Here in section 299, it has been like added about the electronic means. That it's not only about, how the speaking or the writing or the sign or the visible representation which can cause any malicious intention or there is any deliberations to cause any outrage of the religious feeling. But also, if it is through the electronic means, if even through the electronic means there is deliberation or intention to insult or attempt to insult any religious feelings, that will be penalized with a description of imprisonment extending up to 3 years with fine or with both. So you can just understand, kindly mute yourself, So you can just see that electronic means, owing to the technological advancement that our country is observing. And since we had this IT Act and all, But then again, the provision are made within the criminal laws, and which will be, which this is going to be very beneficial. I hope so, at least I hope so that it's going to affect. Because the punishments, the penal provisions given in this statutes, probably the penal provisions given in the criminal laws will be better and more effective. Chapter 17 of offenses against property. Theft. Now, the punishment for the theft, if the property, or if the value of the stolen property, if it is less than 5,000 rupees, if the, and moreover, if the person is a first-time convicted, and the value is returned, or the property is returned, or there is a, restoration of the stolen property, or there is a return of the value of the property, then if he is the first time, doing the theft, then he will be given the punishment of the community service. Because again, as I told you in first two sessions, the motive of the Nyaya is to rehabilitate rather than to create a fear. And for this purpose, the punishments for petty offenses is given community service. But again, there are conditions which are going to be observed by the court before they pronounce the community service. 304, theft by snatching. Now, this is new provision. New provision, and I would say it was actually needed. Because snatching is also taking possession of the other person's property. There also the possession is changing. So yes, theft by snatching is there, it's included in 304, a new provision where the punishment may extend to 3 years, or the person is liable for the fine. The scope of the offense has been widened to include theft in means of transportation and place of worship. So earlier, it was, when we talk about theft, it was only about the human dwelling places where the person is, living. And if there is a theft, or if a person is in a locality, or, or a compound where there's an outhouse also, so outhouse will also come within the human's dwelling place, right? But now they have widened the scope, to add transportation also. So if the theft has happened for any vehicle, or theft has happened in any place of worship, they will also come within the ambit of Section 305 of BNS. The punishment will be for 7 years, and the person shall be liable for the fine also. Now, the fine will again be decided. See, here the fine amount is not mentioned. If you remember, I just told you in few of the provisions of the IPC, where the fine was not specifically mentioned, in BNS, there has been the specific mention about the fine. Even in BNS, this is open. The fine amount at few of the sections, it has been reserved, Now, this fine amount is at the discretion of the court to decide, depending on the value of that product, value of that property. But yes, imprisonment punishment is confirmed. 308, extortion. Illustration E is added pertaining to electronic device. Section 388, Section 389 IPC, it's deleted now. For dacoity, punishment has increased to 10 years. Now word cheating has been added. (310). The word in dacoity, if 310 is talks about the dacoity, where the punishment has increased for a period of 10 years. Now, in 114, section 114, their minimum and maximum punishment is also given. What can be the minimum and what can be the maximum, punishment, that is also there. So minimum can be 6 months, which may extend to 2 years and with fine. So now this minimum was not mentioned in IPC, which is now mentioned in BNS. (324). See, throughout this, chapter, there is increase in the fine amount. There is increase in the imprisonment. Now coming to 324 of this chapter, which is about the mischief. Now this clause 4, which is a new addition to the BNS, which was not there in IPC, and it says that whoever commits mischief and thereby cause loss or damage to the amount of 20,000 rupees or more but less than 1 lakh shall be imprisoned with imprisonment of extending to a term of 2 years or with fine or with both. Now see here, earlier this amount was not mentioned. So keeping this, mentioning this amount, 20,000 but less than 2 lakh, it is actually a rehabilitative, provision. And it will again, make, if it goes for a summary trial, because the amount might be less than 20,000 or it's between the 20,000 to 1 lakh and probably not a severe offense, then it's going to, lessen the burden on the court. Hence, it's actually a welcoming thing that the price, the range 20,000 to 1 lakh is given. Earlier, if I was just going through the IPC, this amount was very meager. It was 50 rupees. If any person who has done damage to any property, any object, where the amount or the value of that product or object was rupees 50, then he was penalized. But rupees 50 of that time and rupees 20 to 1 lakh of present time, moreover, I feel it's same. 325. 325 in IPC, it was given that, mischief by killing or maiming any animal. Now the value of that animal was rupees 10 to rupees 50. Now this has been deleted. Irrespective of whatever is the value of such endangered animal, if any mischief is done and whoever commits this mischief, he will be liable for the punishment, which may extend to 5 years, or with fine, or both. So this amount, the value, the mention of this amount of, this rupees 10 to rupees 50, which was in the IPC, it has been deleted. Section 327. It talks about mischief with intent to destroy or make unsafe a rail, aircraft, decked vessel, or one of 20 tons burden. Now see, earlier also this provision was there in IPC, but then it was limited to vessels and one of, 20-ton burden. But rail and aircraft is now added. Again, I would say the guidelines given by the court judicial pronouncements, where the aircraft hijacking, derailment of railways, damaging the product of this property of the railway, or creating any nuisance in the aircraft which can cause discomfort to the public. So these were some, railway or aircraft were some of the provisions which never came to the mind of the, when the penal, our penal code was enforced. So this is, again, I'll say about the influence or the guidelines of the judicial interpretation, judicial judgments. To 329, again, is the same. The amount of the punishment, amount of the fine is enhanced from 500 to 5,000. Section 444 and section 446 has been deleted. Chapter 18, relating to the offenses of documents and the property mark. Forgery. Earlier, the birth certificate, all these were already there when it comes to the forgery of the document. But now the identity cards like Aadhaar card, voter ID, or documents by means of electronic record, they are added. Owing to the technological advancement, owing to the recent developments that our country has underwent. Section 341, Clause 3 and Clause 4, they are new provisions. Now this Clause 3, Subclause 3 says that whoever possesses any seal. See, this is Section 341 is about making or possessing counterfeit seal with intent to commit forgery, punishable under Section 338. Now, this punishment is, it can go to the extent of 10 years and shall also be liable for fine. So, Clause 3 says that whoever possesses any seal, plate, or other instrument, knowing the same to be counterfeit. So the person is aware that such seal, such plate, or instrument is counterfeited. Then he may be punished with imprisonment of which can extend to 3 years and shall also be liable to fine. Now, Clause 4 says, whoever fraudulently or dishonestly uses as genuine any seal, plate, or other instrument, and under an impression, knowing or having reasons to believe that it is counterfeited, then he shall be punished as if he himself had made those seal, plate, or instrument. Chapter 19 of criminal intimidation, insult, annoyance, defamation. See, in IPC, defamation was in chapter 21. And in BNS chapter 19, chapter 21 and chapter 22 of IPC, it has been clubbed together to form chapter 19 of BNS. Now here, section 351, this phrase by any means, this is added. Now, if I read the statement, if I read this section 351, which says, whoever threatens another by any means with an injury to this person's reputation or property, or to the person or reputation of anyone in whom that person is interested, and there is an intent to cause or the action to cause such, then he is legally entitled, or it will be assumed to be a threat, and he has committed criminal intimidation. Now here, when it says by any means, it has given a wider meaning to it. Now suppose if a person has kidnapped any person's kid, and by way of message, by way of WhatsApp, if he writes a message saying that if you will not give me, any amount or any thing in lieu of the child, then I will kill your child. So he will be held for criminal intimidation. But here, the mode through which the message was communicated, it's through the WhatsApp, right? So again, the IT, again, the electronic mode. So this has increased, and this has widened the meaning to this section, by any means. So it no more remains a physical mean only. Section 353. Now, section 352, it is about the summary triad. So I'm not going into the summary trial because I'm assuming that you are aware about what is summary trial and how many kinds of trials we have in our criminal law. So I'm just assuming that you all are aware of it. So I'm not going into it. Section 353. Whoever makes a publishes or circulates any statement which is false information, rumor, or report. Now, this publication, this transfer of message, if it is through the electronic means. So this is statement conducting to public mischief. Conduct in public by a drunken person. Now, this example, when we were discussing about the community service, when I was telling you about this petty offenses, that time I gave you this example, that if a nuisance is created by a drunken person, then the punishment will be given for the community service. Also, if, the person is a regular offender, or depending on the nature or the situation, the circumstances, he can also be given a simple imprisonment and a fine which can extend to 1,000 rupees. Now, see, if any person who fails to perform the community service as given by the court, then the court can give him simple imprisonment and can also, ask for a simple fine if such person fails to perform community service. Section 356, you understand what is defamation. And since chapter 21 and 22 of IPC is clubbed in section 19. Hence, I have given here mentioned here the defamation so that you can understand it in a proper manner. Last chapter is repeal and savings. Now, this chapter 20 of repeal and savings, you will not find in IPC because there were no previous penal provisions there were no previous penal provisions before IPC. Hence, IPC did not repeal any of the previous, since it was not there, so it did not repeal any. But since BNS has repealed Indian Penal Code, hence this repeal and savings. Moreover, any filing, any case, if it is registered before the police, or any proceedings before the court, any criminal proceeding before the court, if that has been initiated before 1st July 2024, then IPC, CRPC, Indian Evidence Act, that will prevail. Any report, any proceedings, criminal proceedings, which are registered or the proceedings happening after 1st July 2024, they will be within BNS, BNSS and BSA, Bharatiya Sakshya Adhiniyam, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Nyaya Sanhita. Because criminal laws, they do not have retrospective effect. Their nature is prospective. Okay, so with this, I end this session. So any query, any question, any one of you want to ask, you are free to ask me. Yes, any query. I'm planning similar kind of sessions for BNSS, which replaced CRPC, and BSA, which has replaced Indian Evidence Act. In coming time, probably in the month of August, so that you have an understanding, at least a basic understanding about our new criminal laws. So any query, please feel free.
Ma'am, I think
Yes.
I could not attend yesterday's class, but I went through the Bharatiya Nyaya Sanhita. Uh, I I still feel many of the changes or the modifications that have been done
Mhm.
are only keeping in mind some of the past cases where we we had to judicially interpret certain exceptional cases where the nothing is explicitly mentioned in the IPC. I think those things are little. I mean, those things are covered in detail, but I don't think there are any major changes to this. Yes, as you said, sir, the fines and all certain things have been quite um, meaningfully updated to the current uh, you know generation. they were very old things, 50 rupees, 10 rupees. These were very old, cash fines that have been modified, which sounds correct. But there is no major change that we see. But there are many places where new things are added, which are quite interesting, like addition of this the covering the rail and mishap, person causing mishap to rail and aeroplanes. Those things. I think there are many new things that have been added, and including cybercrime as well. Many new things that have been added, but to the existing law, I think there is only some fine tuning that have been done, um, without making any drastic changes.
Jagan, see, I would say few of the provisions, as you said, depending on the judgments that have come. But then these judgments, they have affected the society at large, right? And that was why these were taken into consideration and why it has been there in this BNS. So, yes, as far as enhancement in the fine and imprisonment is concerned, uh, because the rest of the things are same, just here and there it has been increased. And as you correctly mentioned about the cyber crimes, ITs, about the railways, about the aircraft, snatching. So BNS has given room to all these things. So
Yeah.
again,
Yes.
it will be again it will be the time which is going to tell us whether this changes, okay, as per the legislators, whether these changes, are they actually drastic or, they are the same. So it depends on the implementation also, how this is being enforced, how this is being implemented. So,
Absolutely correct, ma'am. I
yeah,
think.
so
I
for
think.
this,
Yeah.
for
Yeah. Go
this,
ahead.
Jagan, I think we'll have to wait little a while to see how it is, progressing.
Yeah, this is what I was actually about to say. It
Yeah,
looks like this is the beginning, and
correct,
there are going to be lot many changes going to be incorporated to make the Bharatiya Nyaya Sanhita more meaningful to the um, I mean to the Indian legal system, and there is a lot going to come in
true.
terms of the
Agree.
improvements. It looks like that.
Agree. I totally agree with you. I totally agree. Yes, anyone else who wants to give your input? Thank you, Jagat. Thank you.
Madam, the sections,
Yes.
most of the sections, same penalty and same offense have been described.
Yeah.
So it would have been better to keep the same sections. Wherever the alterations was needed, there only they could have added, or the whole section could have been written as a deleted, because the whole Indian jurisdiction, all the advocates, every judicial process needs to be again relearned, because we are new. It is not a problem for us. For the people who are already practicing, it may be a lot of it may create a lot of confusions.
Correct. I agree to this because advocates, lawyers who were in practice, these sections were on their fingertips. Now, yes, it will be difficult. And now I'll also tell you, Guru Prasad, since I think you missed other two sessions. In IPC, there were 511 sections. Okay, and they were all these sections pertaining to a particular act, they were scattered. But in BNS, all the sections pertaining to particular act, they are in one place. For example, if you see the definitions itself, section 2 of BNS, which gives the definition. And if you see the IPC, section 2 to section 45, it was all about the definition. So for the simplification, for the purpose of clarity, what has been done in BNS is all the definitions, they have been taken as, and they have been put all together in section 2 with the subclauses. So it has become easier. Okay, and yes, it has been done. See, There are punishments are defined, acts are defined, associating punishments are defined, and there has been the clubbing of many sections as well. So the BNS, the present BNS, it is actually very simplified. If you just go through the bare act, no, you will be able to understand it in comparison to what you did in IPC. So just give it a try. Just go through this bare act of BNS. Probably that will help you. Okay.
Ma'am,
Yes,
I
sir.
was going through, sorry to interrupt, I was going through some of the critics analyzing the missing elements in the Bharatiya Nyaya Sanhita. And quite a lot of information that is there. Like I will only highlight section 377. This section 377, they have removed this section, right?
Correct.
Doesn't return this section, but this section was very crucial actually, and it was actually expanding to many things. I don't want to elaborate that, but I think you will get a sense of how it is going to impact the society. That is where I was pointing that there is a lot many change going to come, because this is going to be a big issue.
Correct. Correct.
We have we in India have already allowed, accepted, the LGBTQ as a transgenders as another sex, right? As another, like we have male, female, and transgender, that has been included.
Correct.
At the same time, we talk about principles of equality and non-discrimination, right? So if you look at that, there are many things that are not being highlighted. One thing is, whenever one of the section talking about rape of woman, but it doesn't talk about rape of female. It doesn't talk about rape of male or transgenders. There are many gaps in that. That is what I was pointing. I think the second thing that I observed in yesterday's analysis, someone was doing it. That guy is a very I think he's a jurist, and he was talking about yes, they have done they have brought changes by including community service, but they have not defined what constitutes community service.
Correct.
And it is again left to the judges to decide. Community service means what? They have only brought the uh, inclusion of the word community service, but community service as such is not well defined. What constitutes community service? So like this, there are many gaps which are going to be addressed in the coming days or months once
Correct.
the implementation goes into full force.
Yes. See, Jagan, as far as this equality and discrimination is concerned, and to maintain this equality only, it's LGBTQ and transgender, they have been given these rights. Earlier, any kind of crime against them, they were not able to report it. But since now they have the identity, they are being recognized as a citizen first, probably they will be able to exercise their right. So it is in order to maintain the equality, the concept of our constitution. Okay. And yes, that's very true. Even I was wondering if they have, taken this concept of community service, then why haven't they described it properly? They should have given the minimum and maximum, right?
Yes, at least some explanation to
Yes. So again, this will give some power to the judges. So let's see how it is. It's an experimental thing. It's totally experimental. And
yeah.
it's the time only is going to give the response. How is it working? Is it working in Indian scenario? Because it has been taken from different, countries' criminology. So how is it reacting with the, how is it with the Indian scenario? Time will say. We need to wait and watch on it.
Yes, ma'am. Absolutely.
Hello, ma'am.
Yes.
Ma'am, is this now whatever writing the bar council exam now, no AIB, this new law only we have to write or the previous one?
No, 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 no. You are writing when? This year?
Yeah, ma'am, this year.
When is the exam?
Now, actually, enrollment has done this month only. This year, I have to write the bar council exam, so I must.
No, Sahana. Then you
Okay.
will be studying about IPC, CRPC, and Evidence Act.
Not this Bharatiya Science.
No, no, this because the questions which for the AIBE, they must be prepared by now. So it's better to go through the old criminal laws. But yes,
we have to
there is
buy
no
the
harm.
previous books only, no, ma'am, not the
Yes,
current.
yes, yes. But then there is no harm to in going through at least the gist or the bare act of the new laws. But yes, as far as the exam is concerned, it will be on the old criminal laws.
Okay, ma'am. Is it possible to send the screenshot to the groups, ma'am? Whatever the slides, whatever you have given in the classes?
Uh-huh. I'll see to that. Okay. Anyways, I
Okay.
think Abhilash sir, he will be sharing with you all the YouTube link also. So you
Okay.
can just save it and you can go through it whenever you feel like.
Okay, ma'am. This bar council is confirmed that previous IPC and CRPC only.
Correct, correct, correct.
Okay, ma'am. Thank you so much.
They must have given the notification also, right?
Actually, I'm not getting the notification, ma'am. I'm little bit confused. What should we read, this current or previous?
No, it is anyhow, it's previous, but I'll suggest you to go through the notification once. What is the
Okay.
syllabus they have given for this time?
Okay. Okay, ma'am. Thank
Okay, so it will be through, it will be on the basis of your syllabus only, and it will be on the old law.
you. Okay, ma'am. Okay.
Okay, okay.
Okay. Thank
All the very best for your exam then.
Thank you, ma'am. Thank you.
Ma'am, any guess when the BNS is going to come in replacement of IPC?
It has already replaced IPC, Harsha.
In the academic, from the
Okay,
examination
in
perspective.
academic. See, academic, it will totally depend on the universities, this education council. So I hope and I wish that it comes in practice from the next semester.
Ma'am, this BNS has already undergone one amendment. It looks like today it is called BNS 2.
No?
Yeah, it has undergone one amendment. I think that is what they are talking about, and it is undergoing another phase, review phase, and
Okay,
then BNS third will come.
okay. Jagan,
See,
just share this reading, no?
yeah, I will share, ma'am,
Yes,
and I
just
will
share this
also
reading.
I also want to highlight one more point,
Haha.
which is very interesting from the IPC perspective,
Okay.
which all the participants should remember that. See, the marital rape has been removed from the current BNS. It is not now a rape.